welcome everyone who has come to attend our monthly webinar. We are so lucky today to have Marisol Garcia and Toni Kokenis join us. Marisol is the Senior Director for the Health Law Advocates Mental Health Advocacy Program for Kids. Her legal career has been dedicated to advocating for children and families. Since 2016, Marisol has directed MHAP, Mental Health Advocacy Program for Kids at Health Law Advocates. MHAP for Kids advocates for children in the Commonwealth with unmet mental health needs to receive the care that they need to be successful at school, at home, and in the community. Marisol joined HLA in 2015 as a mental health advocate. From 2012 to 2014, Marisol litigated before the SSA, representing disabled adults and children. And from 1999 to 2011, she maintained her own law office, where she specialized in juvenile justice, representing children in civil and delinquency proceedings. Marisol was a Bart J. Gordon Fellow and staff attorney from the Children's Law Center of Massachusetts from 1997 to 1999, and she received her JD from Northeastern University School of Law in 1997, and her BA magna cum laude from Providence College. Toni Kokenis is a staff attorney at the Mental Health Advocacy Program for Kids at Health Law Advocates. As an attorney representing Suffolk County, Toni provided direct representation to families in order to increase emotional success and improve health outcomes for children with unmet mental health needs. Before joining the MHAP team, Toni served as Assistant Regional Counsel for Boston's Department of Children and Families. In addition to her law degree, Toni holds an MED degree in Human Development and Psychology, Child Advocacy from Harvard University, an MA in Sociology from Stanford University, and BA degrees in both Sociology and Human Biology from Stanford University. Now, you are wonderfully qualified, both of you, and we are so very happy to have you here today to present about what families need to know about CRAs and 51As. Thank you so much for joining us.
Thank you so much for having us. We're so grateful to be here today to talk about this topic with all of you. And I always love to collaborate with the Federation and with Eileen. So I had some computer problems this morning, so hopefully Toni's got this all squared away. Thank you, Toni. Great. So the topic that we're discussing today is what families need to know about 51As and CRAs during remote learning. So I'm going to tell you a little bit first about our program, and then Toni is going to present about 51As and care protections, and I'll talk about child requiring assistance petitions. Next slide, please, Toni. So Eileen presented a little bit about MHAP for Kids. We affectionately call it MHAP for Kids. The H is silent. The Mental Health Advocacy Program for Kids improves the health and increases the educational success of kids with unmet mental health needs. And the mission is really to divert kids from possible or further court involvement and accessing needed mental health services. And we do this by providing an attorney trained in removing barriers at no cost to families, to low-income families. Next slide, please. We are based on the Family Resource Centers. This map shows where all the Family Resource Centers are. The Family Resource Centers that are based out of the Department of Children and Families serve families statewide. We are based out of 10 of the Family Resource Centers, and those are the darker stars where our attorneys sit. However, they serve the rest of the county in which they are in. We collaborate with FRCs to achieve their mission of diverting kids from the court system to health and social services. And this furthers the objective of CRA reform, which is Chapter 240 of the Acts of 2012. Next slide, please. Sometimes people ask me if the program works. Boston University School of Public Health indicates that we have a proven track record of significantly improving the lives of high-risk youth and their families in a cost-effective way. We've been collecting data since 2015 on the work of our staff attorneys, and we continue to collect data, and specifically data about the COVID pandemic and how it's impacting families, as well as how remote learning is going. An independent study by Boston University School of Public Health found that the program substantially improves kids' mental health while dramatically decreasing the use of emergency mental health services and reducing school truancy. Next slide, please. So we provide free legal representation, and we ensure that health insurance companies, state agencies, and schools provide mental health services to income eligible families. We advocate for diversion from the juvenile justice and child welfare systems. Next slide, please. We serve hundreds of families, and we do this by attending special education team meetings to advocate for eligibility for services or improved services. We seek eligibility and services from state agencies like Department of Mental Health and DDS. We advocate for diversion from the juvenile justice system and juvenile detention while we seek appropriate services for kids. And we ensure that families have access to health insurance and health insurance coverage. Next slide, please. We all know that COVID-19 poses risks to youth mental health, and it creates new barriers to treatment and increases mental health needs. So as we are alluded to a little bit earlier, extended school closures mean that there is inadequate learning plans, there's lack of translation services, kids are losing specialized instruction and therapeutic services. Social isolation is the loss of existing therapeutic and academic supports for kids, an increase in symptoms of depression, anxiety, and post-traumatic stress disorder. And the economic uncertainty and loss of employment can lead to increase in household stress and violence. Next slide, please. We know that extended school closures, inadequate remote learning plans can impact youth educational success. The COVID slide is a concept that an additional amount of learning loss in reading and math skills that are traditionally lost in a regular school year. Kids that are experiencing remote learning and COVID-19 are likely to experience even more significant losses due to inadequate educational and therapeutic. Next slide, please. So one of the things that we've done in order to document regression during remote learning is that we created a weekly extended school closure log to document educational regression, loss of skills, and mental health concerns. And we're using this data to advocate for compensatory services for kids, as well as new services for kids in their IEPs when school resumes. And we have enlisted the support to collect and analyze this data along with our ongoing data collection from Boston University School of Public Health. And we can send these slides to you in case you're concerned about my pace. And also we can send these materials with you about documenting regression. I just know that we have a lot of ground to cover. And so I just want to make sure that we get to all the things.
Next we are slide. Also, excuse me, I'm sorry, Marisol, we're also recording this presentation. So
oh, there you go. That's right. We're recording. So as I indicated, Boston University School of Public Health is analyzing and collecting data for us. And basically the data that we collected last spring in 2020, 48 families participated filling out weekly logs that I just discussed. And the qualitative comments from families suggest that youth social, emotional, and behavioral challenges were made worse during COVID-19. We continue to collect this data, and we continue to see similar remarks, like the harder that she works, the more unstable she's being. It's not fair that the school aren't working with us to accommodate her. 60% of parents and guardians rated their youth mental health at or below a score of 5 on a scale of 0 to 10, where 10 is the worst and 10 is the best possible mental health. So kids are really struggling. We have the vast majority of parents reported observing social, emotional, and or behavioral challenge, and the average family reported about 3 challenges per week. We're seeing that middle schoolers are struggling and that anxiety is increasing for kids. Next slide. This is a sample of our letter that we want to share with all of you in order to make sure that we're documenting those mental health concerns, and also kids' inability to either attend school or participate remotely. So we want to make sure that if kids' mental health symptoms are interfering with their attendance or their participation, we want to make sure that families are able to send a letter either to the special education director if there's existing special education services, or anyone who would evaluate a child and say, these are the concerns that we're seeing during remote learning and COVID-19. And we want to document this to let you know that this is preventing them from participating meaningfully in a remote learning or in person. And we would like to ask for modifications of their IEP or accommodations, etc. Next slide, please. If anybody is still struggling with having a Chromebook, there's another sample letter that we have about making sure that families have Chromebooks. Sometimes Chromebooks get damaged or lost due to circumstances beyond the family's control, like homelessness. So we want to make sure that everyone has access to a Chromebook that needs one. And so this is a letter that can allow families to request that if that is a concern. Next slide, please. The information about return to in-person learning. So as you all know by now, Friday, March 5th, the Board of Elementary and Secondary Education voted to give Commissioner Riley authority to determine when remote-only education will no longer be an option for districts. The Commissioner determined that elementary school students would return to in-person learning on April 5th, and middle school students return on April 28th. Districts were allowed to apply for waivers to delay return to in-person learning, and parents still have the option to choose remote learning for their children through the remainder of the school year. Next slide, please. And now I turn it over to Toni to talk about 51As.
Great, thanks, Mari. Okay, so we're going to dive into 51As here, and we'll start with an overview, look at the filing process, talk about what happens after a 51A is filed, briefly look at the impact that COVID has had on the filing of 51As, and then of particular importance is tips for what to do if a 51A is filed on you or a family that you're working with. Great, so what is a 51A? So 51As are the initial reports of abuse or neglect to DCF. They're called 51As just based on the statutory section that they're named after, which is marked there. And important to note that mandated reporters are required by law to file 51As. And this includes filing on a child that is sexually exploited or concerns if a child is being trafficked. Important to also note that staff at the Family Resource Center are examples of mandated reporters. Other examples of mandated reporters include teachers, early education, preschool, childcare, or after-school program staff, any person at a program funded or licensed by the Commonwealth that's providing residential childcare services, childcare resource or referral agencies, family childcare programs, social workers, physicians, and other health-related professionals, foster parents, and licensed human service professionals. So a lot of people that we work with every day are mandated reporters, so just helpful to keep in mind and understand what a mandated reporter is and who a mandated reporter is. In filing a 51A, this is for concerns of abuse and neglect, and it's also helpful to be clear about what the definitions that DCF is using are. So abuse is defined as the non-accidental commission of any act by a caregiver which causes or creates a substantial risk of physical or emotional injury or sexual abuse. It can also be the victimization of a child through sexual exploitation or human trafficking. Neglect is defined as failure by a caregiver, either deliberately or through negligence or inability to take actions to provide a child with minimally adequate food, clothing, shelter, medical care, supervision, emotional stability. And this important to note that this is not supposed to be judged or due based to inadequate economic resources or the existence of a handicapping condition. 51As also must be filed on a caregiver. So a caregiver can be a parent, a step parent, or guardian, but it can also be any household member that's entrusted to be taking care of the child in regards to their health or welfare. It can also be any other person outside of the home setting that's responsible for taking care of the child and their welfare. So this would include school teachers, babysitters, camp counselors, bus drivers as well. So when a 51A is filed, so when you call a mandated reporter or a non-mandated reporter called to file a 51A, the report is screened by DCF. And DCF is looking at Does the allegation of the filing, does this meet the criteria for suspected abuse or neglect based on the definitions that we just saw on the previous slide? And to determine this, they'll be talking to the reporter, gathering as much information as they can. They can also talk to collaterals as well. The reporter will decide if they're screening in the filing or if they're screening it out. So if it's screened in, then this will lead to a Child Protective Services response, and they'll be looking at, is there a reasonable cause to believe that the child has been abused or neglected? If a call is screened out, the DCF workers determine that this does not meet the criteria for abuse or neglect, but even if a 51A is screened out, it can still be referred to the district attorney. For instance, if it's concerns against someone who is not a caregiver or in instances of extreme physical abuse or sexual abuse. This is just some stats from the previous fiscal year. I think a particular note is you have 37% of 51As are screened out. 6% we have going to district attorney for referral, but you have about 56% that are screened in, which then go to an investigation. So what to do when a 51A is filed. So these are just helpful tips for all of you to keep in mind, that any statements that you make or any observations that the social workers make can be used against you. So this could be anything they see in talking to you, if they're looking around your house, anything they see, they're taking notes on, and all of that can be used against you at a later date, for instance, in a court setting. Do not talk about anything for which there might be pending or potential criminal charges. If you receive a call from DCF, you actually have the right to refuse to speak to them, and you also have the right to have an attorney present when you are talking to them. If you receive a visit from a DCF social worker, you also have the right to refuse to let them into your home, and you have the right to have an attorney present during that visit. If you do have anything that addresses DCF's concerns, such as proof of being in therapy or paperwork that shows that you did take the child to the doctor, for instance, having that ready with extra copies that you can then just directly provide to DCF is always helpful. And important to note that you are not required to disclose your immigration status. Okay, so following a 51A being screened in, it results in a 51B investigation. So this will be an investigation of the suspected abuse or neglect. And this is determined, it's either an emergency or a non-emergency investigation. And this just refers to how quickly the investigation will be completed. If it's an emergency, for instance, once that report is screened in, the emergency investigation must begin within 2 hours, versus if it's a non-emergency investigation, it must begin within 2 business days. So things that happen during an investigation period, this will include home visits to view the child, if that's appropriate, or home visits to view the setting where you're living. There will be an evaluation of parents in the home environment. So again, this would be interviews with parents, the reporter, they'll be talking to collaterals. They'll also be viewing the home if you let them in. They'll be looking to determine the nature or cause of injuries as well, if that's deemed appropriate. Okay, so some important considerations when filing a 51A, and this is particularly relevant for school settings, and if there's filing for not attending school or not taking care of your child in that manner, the school district should be exploring and documenting all possible opportunities to support and assist the students and their family to overcome barriers to engagement and attendance. So the school should be working with you, working with your child to address technology barriers that are coming up, such as access, whether that's through a Wi-Fi hotspot or whether that's through access to a Chromebook. They should also be considering what other supports does your child need in order to access and engage in a remote setting or the return to in-person. And they should also be considering what other alternate learning opportunities would be available to support this engagement. So these are conversations the school should be having with you before a 51A is filed. Another thing to consider is has the school or district reviewed data to identify whether there's an over-reliance on 51A filings on a certain student group. So this, for instance, are there more 51As filed on students of color or students with disabilities versus white students in the school? The DESE guidance specifically says that schools and districts should consider the many factors that contribute to lack of attendance, including being on camera, lack of access to necessary technology, difficulty finding appropriate spaces for learning, and language barriers as well. And their guidance further states that by employing the support and intervention strategies highlighted throughout this document, schools can engage with students and their families and community providers to understand and address attendance concerns, maximize participation, and facilitate re-engagement. So being aware of this DESE guidance can be helpful in thinking about how to work with the school before a 51A is filed, and hopefully get that support prior to a 51A. Okay, so care and protections. This is the court process that can result from a 51A being filed. So care and protections are Massachusetts dependency cases in which the Department of Children and Families can remove children from their homes because of claims of abuse or neglect. The vast majority of care and protections are filed by DCF, but technically anyone can actually file a care and protection. And once a petition is filed, a court may award temporary custody to DCF if the judge finds that immediate removal is necessary to protect the child from imminent abuse or neglect. Care and protection cases can actually last for years. We'll go through the timeline, but just flagging that they often last a lot longer than they're technically supposed to. I also see that there are questions in the chat. I want to get through this section. I know we'll have time for questions, hopefully at the end of the presentation. Okay, so children removed from their home can be placed into custody with family or kin, or placed into a foster care system. And kin does not need to be blood relatives. Those could be godparents, very close family friends. The department does want to try to keep families together, including extended family. In the vast majority of cases, the goal is for the child or children to be reunited with their parents. So that is always what the goal starts off as well. Other outcomes include guardianship, adoption, another permanent planned living arrangement, and that's specifically for older kids where it's been determined that permanency through other means is not possible. Okay, so this just shows a timeline of the court process. So you have a care and protection is filed, a 51A and 51B investigation would have happened prior to this. You have what's called a 72-hour hearing. 2 to 3 months later, you have the motion status hearing. You'll have multiple court dates checking in with court here, and then you have a permanency hearing at 12 months, and then a hearing on the merits or a trial regarding the permanency of the child, which we'll go into each of these next. Okay, so the temporary custody hearing is also known as the 72-hour hearing. So after a child is removed from the home, this is the parent's initial hearing on the removal for them to argue that for instance, the child should not have been removed from the home and should be placed back in the home. Only each parent and or guardian and any children are entitled to a lawyer, and potential outcomes from a temporary custody hearing include dismissal, the child returning home subject to conditions, a temporary custody order continued to DCF, temporary custody to a non-custodial parent, or direct custody to a third party. The other court dates that were on that timeline included the motion status. You'll also have status conference and pretrial conference. And these are all cases that will happen every few months as we move closer and closer to trial, which will just be an update with the court on what's happening and the status of your work with the department and progress for the case to be dismissed, hopefully. The hearing on the merits or the trial should occur within 15 months after the initial petition is filed. But as I mentioned before, this often occurs much later and can be years before a trial actually happens. And permanency hearings happen every 12 months, and those are to review the department's plan in seeking permanency for the child. And this graph just shows that even if families are working with DCF, so there's an open clinical case, 80% of the children involved are still remaining in the home, even if there's an open DCF case. And I know these numbers are very small, but this chart is showing the impact that COVID has had on care and protections. And as you can see, there's really been a drop in the number of care and protections since COVID has happened. So we see for Barnstable, it's a 38% drop from the previous year. Essex is 27% drop. Suffolk, 25% drop. And this is just zoomed in even more to show the same themes that we were just talking about. Cool. And I'm going to pass it over to Mari now for an overview of the CRAs.
Thank you, Toni. I want to answer just one of the questions that's in the chat about the Alman report and how the OCA had made new recommendations in that report. I think that there's still a listening period around that guidance. And so I'm not sure that we've seen any changes yet into 51As and 51As being filed in greater numbers as a result of that report. But I think that there are many advocates who are thinking that that will be the case moving forward. And I know that there's a few other questions in the chat that I promised to get to after I talk about child requiring assistance petitions. So next slide, please. What are children requiring assistance petitions? CRAs are the Massachusetts status offense cases. So until 2012, and for most of the time that I was practicing, they were called CHINS cases. And you'll still might hear them be referred by that name. And who can file for them? Parents and guardians, school systems, and police officers can file what we call CRAs. Next slide, please. This is the numbers of CRAs as distributed by county. As you can see, they are not being filed as frequently during COVID. There are some counties, mostly counties with greater populations like Middlesex and Essex and Suffolk that have CRAs in larger numbers. And if you look, the age disparity is there, with most CRAs landing in around the 15-year-old range, and anyone who's had a 15-year-old can understand why that might be the case. Next slide, please. See Tony's cat. Filings by gender by county. As you can see here, there are disproportionate number of male CRAs over females, but not by that much. And total cases were at 35, about 3,600 cases. Next slide, please. The racial disparities are significant here. If you look by counties, in Suffolk, for example, more kids, Black and African American and Hispanic Latinx kids are having CRAs than in other counties, and these digits show that disparity throughout in Essex as well. Next slide, please. One of the startling things we heard from the Boston University School of Public Health in the initial data collection that we've done this time is that 30% of MAP for Kids families were advised to file a child requiring assistance case by clinicians. That was almost 35%, in schools around 33%. And that is concerning to me because of what we will talk about as the misconceptions around CRAs. Next slide, please. And here is the slide that says misconceptions about CRAs. There are a lot of urban legends about what juvenile court judges can and cannot do. And so this slide helps to break that down a little bit. So a juvenile court judge can order custody to the Department of Children and Families. And they also can make an out-of-home order, which means that kids need to be placed outside of their home. And a juvenile court judge can also order custody to a third party, the same way that Toni discussed in a CRA and a C&P petition, where, you know, a kinship person or a child's teacher or favorite neighbor can be a recipient of custody from the juvenile court judges. However, a juvenile court judge cannot, during a CRA only, send a child to DYS. They cannot access counseling services. They cannot access residential services. They cannot access a psychiatric hospital bed or a CBAT. They can't order DCF to access a specific placement, and they don't gain priority access to any mental health services. So there aren't specific slots reserved for the juvenile court. There isn't a prioritization of kids who are involved with CRA cases. I'd love to hear your questions about this during question and answer, because I think there's a lot of really tightly held misconceptions about the CRA process. Next slide, please. There are 5 types of CRA cases: runaway, stubborn kids, habitual school offenders, habitual truants, and sexually exploited kids. Next slide, please. So a parent can file a CRA, and they can file a CRA if a child is running away, a child between the ages of 6 and 18 who repeatedly runs away from the home of a parent, legal guardian, or custodian having custody of the child, and the legislation is there. A stubborn child is a child between 6 and 18 who repeatedly fails to obey the reasonable home rules, thereby interfering with the parent's ability to care for the child and keep the child safe. That's a stubborn child petition. And these can be filed by a parent, a guardian, or custodian, not a police officer. Next slide. CRAs that can be filed by school departments are a habitual school offender, a child between the ages of 6 and 16 who repeatedly fails to obey school rules. A school district may file an application, but they must also state the specific steps that they have taken to improve the child's conduct. And sometimes you'll see that as a separate page in the school filed petitions. These petitions must be dismissed when the child turns 16. Habitually truant are kids between the ages of 6 and 16 who, without excuse, willfully fail to attend school for more than 8 days in a quarter. The school must state whether or not the child and the family have participated in a truancy prevention program. Again, that should be detailed in the petition. And the description of willfully is very important, because it can't be that the child is not participating or not attending due to their disability. Schools filed petitions must be dismissed again when the student turns 16. Next slide, please. Sexually exploited youth is any person under the age of 18 who has become subject to sexual exploitation. This includes anyone who is the victim of sexual servitude or trafficking, engages in sexual conduct for a fee in exchange for food, shelter, clothing, education, or care, is the victim of a crime of inducing a minor into prostitution, engages in night walking or street walking. Under National Laws, Chapter 119, Section 39L, there's a presumption that before or after the arraignment in any juvenile or criminal proceeding against a sexually exploited child, that either a care and protection or a CRA will be filed in conjunction with those delinquency cases. And any person, including the juvenile, may file a care and protection petition on behalf of the child, including a petition for emergency commitment. And a sexually exploited youth CRA can be filed by either a parent or a police officer. Next slide, please. What to do if you find that the school has filed a CRA? If you have anything that addresses DCF concerns, please bring that to their attention. Does your child have an IEP? Do you have recent evaluations? Do you have any letters from providers or caregivers, mental health providers for your child or your primary care doctor? You have proof of services that your child is engaged in, you should provide those to DCF. Any paperwork showing that you took the child to the doctor for an excused absence. Again, you're not required to disclose your immigration status. Next slide, please. The steps in the CRA process, we're going to go through them. The filing of the application, the preliminary hearing, informal assistance, fact-finding hearing, conference, disposition, additional hearings, and dismissal. Next slide, please. So what are the parents' rights? You have a right to attend all the court hearings, to be represented by an attorney at any hearing where the judge considers removing a child from your custody. You're entitled to a language interpreter if you need one, and you can have other courts review decisions of the juvenile court judge on your case. Next slide, please. The child has the same rights as the parents. They have the right to be represented by counsel at all hearings. They're entitled to appointed counsel regardless of finances of the parent or guardian, and the child may not be confined in shackles or in lockup in connection with the CRA matter. Next slide, please. When a CRA application is filed, the clerk is supposed to inform the applicant about community-based resources, including the family resource centers where our program is based, the court process, and the possibility of a custody change. And there should be a notice with the date of the preliminary hearing that is sent, and a summons may be issued if the clerk determines that the child is unlikely to appear at a preliminary hearing. Next slide, please. At a preliminary hearing, that must be held within 15 days of filing with child's counsel present. The process is that there's an immediate inquiry. The probation officer, that's what PO stands for, will interview the applicant and the child, and they will make recommendations to the court. Possible outcomes are that the court can decline the application if there's lack of probable cause. They can decline the application and order informal assistance, and they can also accept the CRA and order for a fact-finding hearing, which looks like a little mini trial. Next slide, please. In informal assistance, the probation officer works to resolve or eliminate the need for a CRA, and so the applicant and the child must agree. The probation officer can make referrals. They may extend it for 90 days and for an additional 90 days following that. So after 90 days or after the additional 90 days, which would be 180 days, the court either has to schedule a fact-finding hearing or dismiss the application. Next slide, please. At the fact-finding hearing, there's a bench trial where the court determines whether the statements in the application for assistance have been proved at hearing beyond a reasonable doubt, which is the highest standard. Both parties have the right to be heard, and the outcomes are that the case can be dismissed or that the child can be found to require assistance. And so then they'll schedule a conference and disposition hearing date. Next slide, please. At the conference, the court convenes and may participate in a meeting with probation and the child, the petitioner, the guardian, and if there's DCF involvement, any other helpful person, including the school, will participate in this meeting discussing, how the child is doing and any suggestions for moving forward. And this occurs before the disposition hearing. Next slide, please. At disposition, the judge determines what orders should be entered to help the child. Again, we discussed what some of those might be. The court may permit the child to remain at home, place the child in the care of a relative following a probation assessment, or they can place the child in the custody of the Department of Children and Families. One of the things that Toni discussed when she was looking at the data is sometimes the child is in the legal custody of the Department of Children and Families, but is returned to the physical custody of their parent and may be at home. DCF cannot refuse, though, to make an out-of-home order placement if it's recommended by the court. So if the judge says, I'm making an out-of-home order, the Department of Children and Families cannot refuse to place that child out of the home. But they are entitled to direct the type and length of such an out-of-home placement. So it may be a very short out-of-home placement, like over the weekend or even overnight sometimes, because that is to the discretion of the department. The dispositional term is 120 days, and it may be extended for an additional, for 3 additional 90-day terms. And so that would be a total of 390 days. And where the parent's custody is at risk, again, as we discussed, the parents are entitled to counsel. They may be entitled, both parents may be entitled to one attorney if they're on the same page, and if they're not, they may get individual counsel. Next slide, please. There might be additional hearings and can and often do occur, sometimes as often as once a week, for there to be check-ins about the child's progress. And next slide, please. The case must be dismissed after 390 days, but the applicant can and often does refile a new CRA application. No order may continue after a child's 18th birthday if the CRA was parent filed or filed by police, but no order may continue after a child's 16th birthday if the CRA was filed by the school department. Next slide, please. Is that it? DESE Guidance on CRAs filed by school staff. So this is the guidance, as Toni discussed, that was just issued. There is important considerations before filing a CRA application during COVID-19 is, has the school or the district explored and documented all possible opportunities to support and assist the student and their family to overcome barriers to attendance? Has the school district reviewed data to identify whether there is an over-reliance on CRA filings as an intervention for specific groups, for example, students of color, etc. Next slide, please. The Family Resource Centers are an excellent resource for diversion. As I discussed earlier, they were created by the legislature out of during CRA reform, and under Mass General Laws, Chapter 119, Section 39G, when a petitioner presents a CRA application to the clerk for filing, the clerk shall inform the petitioner that they may delay filing the request and choose to have the child and the child's family referred to a family resource center. The family resource centers are providing community-based services in the juvenile court district where the child resides and return to court at a later time to file an application for assistance if needed. Under Mass General Laws, Chapter 118, Section 39G, the clerk shall prepare, publish, and disseminate to each petitioner educational material relative to the available family resource centers. Every county has a family resource center, and most counties have 2, and some counties have 3. So there should be one providing free services near you. Thank you, Toni. Next slide. So if you have questions, that's our intake line, and I believe there are some more questions in the chat, and I think we have about 15 minutes for questions if folks. So I turn it back to Eileen.
Thank you so much, Marisol. Thank you, Toni. How would you like to do this? Shall I read the questions that are in the chat?
Sure, that sounds great.
Okay. Sorry, I'm going back. Okay.
One of the questions that I see are SESPs allowed to see 51A documents? I can turn that over to Toni to answer if she would like to.
Mm-hmm. If you're reporting for a 51A or filing a 51A, then you will be alerted of whether it was screened in or screened out.
And SESP is a special education surrogate parent. That's right. Actually a program that the Federation recruits and trains and supports people for. And a lot of them are on this call. SESPs have educational decision-making rights. DCF has custody of the child. So.
Right. Yeah, definitely. And so because the SESPs are not a party to the matter, I believe that they are not entitled to have those unless they have a court order allowing them to have access to records from the Department of Children and Families.
Yeah, I think the file or like the 51As, 51Bs of that history would only really be released in preparation for trial if a care and protection is filed, and those will be released specifically to the other attorneys who may or might not share that with the biological parents, but it doesn't go beyond that for access. But yeah. Again, if you file a 51A, you should at least be receiving a letter of whether it was screened in or out in the finding, but it won't have the conversations that occurred and with who.
When I was appointed as a guardian ad litem, at times I had a court order that allowed me to have access to all types of records, but absent that.
Yeah.
There you go.
Well, and when an SESP is appointed, the child is already in care and protection custody. So, and I'm guessing that the root of the question is to do with what the child has been through in terms of trauma, and the impact of that would be something that would be of concern to education, but very often there's no information given to SESPs about what the child has experienced. So, You had mentioned that parents can refuse to let DCF into the house. What happens if you do that? Do they call the police?
So, so I want folks to think about the Department of Children and Families as a government agent, the same way that a police officer is. And just as people are repeatedly told that they have rights to Miranda with regard to answering questions, including the right to be safe from search and seizure in their homes, we don't see the same information given out about interacting with the Department of Children and Families. The Department of Children and Families is a government entity that needs to build their case without any testimony from the people who are accused in that matter. So if they have enough information to proceed with a care and protection without your statements or evidence from you, they will proceed with that care and protection without evidence or statements from you. A lot of times, folks are interacting with the Department of Children and Families, and the Department of Children and Families has not already filed a care and protection case. And if more information is given without maybe the presence of counsel, then it can be more likely that a care and protection case will go forward. I think that if there are concerns about the safety of children, there may be other steps that are taken by the Department of Children and Families. And I think it's important to have knowledge of what the allegations are, but I think it's really, really important for caregivers to know that they don't have to answer questions if they don't want to.
I think one little thing I would add is I think the only time that you would see social workers and police entering the home would be if, as Mari was saying, these emergency situations, or if there were exigent circumstances where DCF has decided that they need to execute an emergency removal of the children before they even go to court. But that's a higher bar for them to prove in court, where they would really need to show that there were exigent circumstances, children were at imminent and serious risk, that if we didn't remove them right now, something would happen. But that would, and in those removals, the police often accompany the social workers. And that would be an instance where they could enter. But again, exigent circumstances, emergency, they've already made the decision to execute or use that power that they have from the state in those situations.
Yeah, I know. I worked with a case that I know you know about, that child was reported, the teacher filed a 51A because there was a mark on the child's neck, which turned out to be a glitter tattoo. But there was concern the child was being choked, and the police showed up at the house that day. No social work, it was just the police. So it can happen. Do we have other questions? I'm looking at the chat and I'm not seeing questions. I can ask you one of mine if you don't mind.
I see one question. Do you see it too, Toni? Do you want to read it, Toni?
Yes, I think it was about if you do not have good internet access.
Oh yes, that one.
Sorry, is there any help for families that have inadequate internet access?
We are still dealing with this.
I think that there is some movement on the part of the legislature to collect some more data around this. And so if you are able to contact your legislator about this, I think it's really terrific. I believe at the beginning of the pandemic, there were some companies that were offering some support around internet access. But as Toni said, before a CRA is filed, the school districts have been advised to support families around this before resorting to court. So I think that there is the importance of notifying the school district that this is something that is a barrier to your child participating, as well as trying to get other folks involved.
Yeah, I know schools or districts were offering like Chromebooks, but as well, I know in Boston, they were offering hotspots for students and families that didn't have stable internet access, but that has also been a challenge to get consistent.
I love that Toni answered this question in the, but I'm just gonna say it out loud. Toni answered that the family resource centers are not only for families with 51As or CRAs that have been filed. They're a great resource for court diversion, but there's also families are going there for support around housing, you know, other mental health needs that they might have. The Family Resource Centers are offering terrific groups, you know, for families, and a lot of these groups are now happening remotely. There's a lot of families, resource centers are supporting families around food insecurity. You know, I know FRCs have handed out hundreds and hundreds and hundreds of bags of really nutritious, wonderful food. So there's some really wonderful things happening at the Family Resource Centers. Each one of them is different, but all of them have shared staff that really carry out the terrific mission of the Family Resource Centers. Someone asked,
I'm sorry, let me just,
no, go ahead. Why don't you go ahead, Eileen?
All of the Family Resource Centers have a school liaison who helps with school related issues, and I support them around special education. So they have, you know, training on special ed issues, and there's no income limit to go to a Family Resource Center. You don't have to be at a certain level. You just can walk in. So
yes,
they're wonderful places.
I'm really glad that you added that. And they also don't ask about immigration status, which also may be concerned to some folks. So I agree wholeheartedly with what Eileen is saying. Someone asked a question, do you collaborate with the Ed Law Project in Boston? So the thing that's interesting about the Ed Law Project in Boston is that it's specifically for court-involved youth. And so they support mostly kids who are already involved in the justice system. And our program is based out of the FRCs, and we can support kids who are based in the court system and who are trying to divert the court system. So that's really awesome. And they are a wonderful resource. And I have worked with them in the past, but we are different in the sense that our clients don't have to be involved in the court system, and that we our scope of representation is a little bit broader in that we're doing all of access to mental health services, not just special education.
May I ask a question about compensatory services, since you brought that up as something that you use data to support? A lot of our special education surrogate parents, our kids are in group homes or residential schools. They're the kids who are in congregate care. Right. And they, we don't often have access to their day-to-day school habits. Those kind of logs may be missing. When we go to look at compensatory services, first, can you clarify for me when are COVID compensatory services covered? Is it just last spring at the end of the 2019-2020 school year, or is it this fall, or do we not know?
So compensatory services are not a COVID created thing, right? So if kids don't get access to services and there's been a lack of services, you're entitled, you've always been entitled to compensatory services. I think that there have been, we really created a toolkit and a lot of documentation around really early on in the pandemic, seeing that some kids weren't able to access their special education services remotely, or that they weren't being offered. So that's really the idea behind looking at, and those services are literally like a 1-for-1. So if you didn't get your speech and language service for an hour, then you go to the school district and you're like, we didn't get 10 hours of speech and language, so now we want 10 hours of speech and language, right? So that's really like a 1-for-1 kind of deal. In terms of another sort of slightly different concept is kids who, because they didn't receive their services during remote learning or COVID, that they need more services, which may be like even a better place to put our efforts behind, because kids are going to need more, and the kids that we all serve are going to need even more. And so really getting that evidence and that documentation for sitting down with the team and planning either for the fall or very quickly in the fall about what we think the kids will need so that they can be supported and be successful.
Okay.
Let's see, I'm reading here in the chat. We have a family who has a 15-year-old who is high risk, has a diagnosis of depression, social anxiety, and borderline bipolar. DCF has partial custody, and suggesting a group home. Can you suggest a guide for this family? I'm not really sure that I can answer this question with the amount of information that I have here. we definitely have the ability for you to reach out to us, after the training, either by email or phone. I know we're really close to time, so I don't know if Eileen, you wanted us to answer any other questions. We have like 2 minutes. Oh, well, here's a question can you talk about when you think it's advisable for a parent to file a CRA? Do you ever think that this could be helpful? Can you talk about parents who have voluntary CRA retained? So I love this question because it kind of goes along with my concern about the misconceptions for CRAs and how I think a lot of folks feel like they will be able to access additional services through the CRA process that aren't necessarily something that the judges can really order. I mostly think that CRAs are helpful if there's a delinquency case pending, to be honest. I think it gives the judges a little bit more leeway when sentencing, and in general, I would really refer the families to trying to access services in the community, like the family resource centers, versus going through the CRA process.
Mm-hmm.
I typically do not think that it is very helpful to go through the CRA process. And I think that you are correct that parents who file a voluntary CRA can retain decision rights for the special education process. They do, because custody through the CRA process is different than custody in the C&P context. So thank you for asking that question. It's a really, really relevant question, and I appreciate it, Mary Beth.
Thank you so much. This has been a lot of wonderful information. I think just debunking some of those misconceptions about what a judge can do with a CRA is just hugely valuable. I wish we could, put it on the evening news.
I agree with you so much, Eileen. I really, really agree with you. So I really, really thank you for having us. I know that all of you are doing this really hard work for the kids who are at most need. And I know that you put your whole heart into it, and it's never been harder than it is right now. So thank you for your commitment, your dedication, your expertise, and your experience. Thank you for listening to us today, and we are here. Thank you to Eileen and Toni for doing such a great job presenting and doing the technical stuff. She's a very, very talented attorney, and I'm really grateful to have her.
And thank you, Toni, for putting your intake information and email into the chat. So
yeah, if you
folks
have
will
any,
know how to reach out to you.
Yeah, if you have any questions, please feel free to shoot me an email and we can connect after that.
Great. Okay, well, thanks very much, everybody. Have a good afternoon.
Thank you.